Okay, we're now officially recording, so just be aware of that. This is so that people can see this afterwards, because some people can't make these. Just to let you know, this is not legal advice because I'm not a lawyer. However, I do give the best advice I can, but if you need any legal advice, please do consult your district lawyer or SDAO or something like that. Feel free to ask questions at any time via the chat box or verbally. Go ahead and interrupt me. I'm fine with that. This only scratches the surface of these topics. There's not enough time to go through all of this, but we'll do the best we can. Mostly what I try to do in my trainings, for those that know, is to get you enough information so you know when to dive deeper and to stop thinking for a minute. Just think for a moment like, hey, I think I need to ask Eric questions or call SDAO or talk to our lawyer. But this is very detailed information. So with that, I'll go ahead and get started. I think we've kind of stabilized with what's going on. Again, put questions in the chat box. I'll be monitoring that. And also, as I said, ask verbally. One of the things that I would start off by saying is that everyone should have a copy of the Attorney General's Public Records and Meeting Manual. This is one from a few years ago, but we have mailed out last year, or actually maybe it was the year before at this point, the most current one. So all of you should have this in your office somewhere. This is where I go to when I'm trying to find answers for folks, and I reference it all the time. For both public meeting and public records information. So we'll start out with what the definition of a public meeting is. There is a very detailed definition, but it's the convening of a governing body, which essentially is any body that is going to be making decisions. So it's not just your board. That's the typical one, but as we'll talk about in a moment, what else that means. It's a body that is going to be deliberating toward a decision or making a decision, that you have a quorum there that is required to make a decision, and then there's an open public vote. So your district board is a great example of what a governing body is, and when they meet, they're making they're deliberating to make a decision or toward a decision, and they also need a quorum to meet. That's fairly obvious and everything like that. So when you start looking at what are governing bodies and public bodies, they're two or more members of any public body. And this is where it gets tricky, and we're going to go through some decisions about advisory boards and committees and subcommittees, all those things. Are they actually public bodies that this law applies to? So governing bodies are your board, and public bodies can be committees and stuff like that. So public bodies include municipal corporations, which you are, committees and subcommittees and advisory groups, where you have two or more members making a decision or a recommendation. So let's, that sounds a little complicated, but we'll step through some examples here, as you know. So the first one is your board of directors. And that's the one that you all are familiar with, is that when they get together and you have a quorum of the positions, not the total number of directors if you have some vacant positions or unfilled positions, but the total number of positions you have. So that's 3 for a 5-member board and 4 for a 4-member board. If they get together then and are discussing district business, leading toward a decision, or making a decision, that's going to be a public meeting. Where it gets more complicated is when you start talking about committees and subcommittees and advisory boards. So if you've got a committee together or a subcommittee, and that group has been given authority by the board to make recommendations or make decisions on behalf of the board, then that is going to be subject to public meeting law. Some of those really obvious ones are your personnel committee, your finance committee, maybe a projects committee, administrative committee, or some task forces, which might be a building committee. If they have been appointed by the board of directors and are going to be making some recommendations to the board or make decisions on behalf of the board, then they are also subject to public meeting law. Where I have no down there, this is important to note. It used to be saying that kind of the general consensus of law is if the group only provided information to the board, then they wouldn't be subject to public meeting law. But in the past few years, the Attorney General has decided, and I'm not sure if it came through court cases or own decision, that if this informational committee is going to be providing information that to the to the full board that the board is going to be using to make a decision, even though it's only information provided, no recommendations, but the board will be using that information to make a decision, then actually those meetings also have to be considered under public meeting law and go through the everything that's related to public meeting law. So the question I get a lot, happens all the time, is if the board appoints less than a quorum of board members to a committee, do they have to comply with public meeting law? And as many of you know, we've been through discussions, the answer is yes. If this committee has been given authority by the board to make recommendations or make decisions on behalf of the board, then yes, it has to meet public meeting law. And it doesn't matter if you appoint less than a quorum. So if you have a 7-member board and you appoint 3 board members, it still has to meet public meeting law, because in essence, this committee becomes its own governing body. And that's important to realize and to think about, is whatever group is appointed by the board, you can call it any name you want, a committee, a task force, whatever you'd like. If it's appointed by the board, it becomes its own governing body, and therefore it has to apply the public meeting law to it also. So doesn't matter if you have less than a quorum. I've also been asked, what if we only appoint 1 board member to a committee? Well, as long as, again, that committee has been given the authority to make recommendations to the board and making decisions on behalf of the board, it's subject to public meeting law. And I've gotten this too. You're going to see a pattern here. What if the board appoints a committee and doesn't put any board members on it? It's still subject to public meeting law. So just think of it this way, that if the board appoints a committee and that committee is going to be making recommendations or making decisions, it doesn't matter who is on it, that committee is subject to public meeting law. So essentially, all your board appointed committees, no matter who is on it, is subject to public meeting law. And so just, if you have any questions about that in examples, feel free to ask me. I'll be glad to talk about them. But essentially, it's going to be public meeting laws. Now, what if you are at a social gathering? You've got your picnic. You have board members who meet up at a bar or on a tour. If you have a quorum of the governing body and they're discussing official business, then technically, yes, it's a public meeting and should be noticed, and everything else as we're talking about as a public meeting. Just general discussions at a social gathering are fine. That's not going to, if it's not about district topics, that's fine. But if you are going to be having any discussion about official business, then yes. So one of the things that comes up a lot about this are like tours. Say you're going to, you want the board and the public to go on a tour of some projects. Well, technically you could probably make it not a public meeting if the board members don't start talking to each other about the project and what it might lead to, other projects that might happen. You have to be very careful about those tours. If you're going to have a quorum of board members there, it's probably going to be a public meeting. Do we have any questions so far about what constitutes a public meeting? Okay, going to move on. So this has actually come up just recently, and that's why I still put this in here about what exactly is a quorum. So a quorum is a majority of board positions. It's not whether the positions are filled, and it's not whether they're at the meeting. A quorum is a majority of the board positions. So if you don't have all the positions filled, you still got to think about all the positions. And by statute, a majority vote of all members of a board must occur in order to make a decision. So the majority vote, again, because we just talked about, is about board positions. It's not about who's there. It's not about filled positions. It's about all the members of the board. And so just think of it this way. If you have a 5-member board, you always need 3 yay votes. And if you have a 7-member board, you always need 4 yay votes to pass anything. It doesn't matter if there's only the minimum quorum requirements there. So if you have a 5-member board but only 3 are there, you still need all 3 yay votes. And if you have 4 members of a 7-member board, you need all 4 yay votes. Someone asked about it, someone abstained from a vote. An abstention is not a yay vote. So if I see your question, I'll be right there. So if you have 4 board members present and 1 abstains, and it's a 7-member board, you only have 3 yay votes. So on a 7-member board, that does not count. You would not pass something. So I hope that's clear because I know that's come up recently. So it's actually quite simple. You just always need 4 yay votes for a 7-member board and 3 yay votes for a 5-member board. Any questions on that? Because I do know that has come up before. All right, Al has asked, we host a guest speaker at a publicly attended event fundraiser. Should this be formally noticed or does the ad sent out on social media count? So here's the question, Al, is you would look at is, first of all, are you going to have a quorum of board members present? If the answer is yes, the next question is are they going to be discussing district business while there? Chances are, if you just have, you're doing a guest speaker series and you have the board members there, you would just want to admonish the board not to discuss board business, but just be there to listen to the guest speaker at this publicly hosted event. If you wanted to make sure, in case they talked, you could notice it as a meeting with the agenda item being the guest speaker, but it's not necessary as long as you make sure that the board doesn't talk. And you ask if this an ad sent out on social media count. Well, if it needs to be formally noticed as a meeting, a public meeting, sending it out on social media is not enough, and we'll discuss that in a little bit future here. All right, next question. Who may attend a meeting? So we're going to talk about executive session next in a shortened bit, but any member of the public may attend any public meeting. But that does not give them a right to participate. So that has to do with public comment. It's a myth that you must provide an opportunity for public comment, except in certain circumstances. But they do have the right to participate. There are some nuances to the law if they become a nuisance, if they're speaking out of turn. There are some instances where you can exclude them from a meeting. The other question that comes up a lot is, can they record or videotape the meeting? Yes, the public may. It's very clear in case law, as long as they don't interfere with the running of the meeting. So they can't go around and put a camera in your face, but if they put a camera up in the corner of the room, they're more than welcome to videotape it. They're allowed to by law. So executive session. As some of you know, I did a session last Friday, an executive session that was very detailed. I'm not going to go into detail here. And I'm doing another executive session later in the week. The reason why this is important, as many of you know, I talk about, is because there are some serious consequences to violating executive session law that includes fines, and just participating in executive session will give you a fine. It's not whether you ran the meeting or not. So an executive session is where you're allowed to close the meeting to certain people to talk about certain sensitive matters. There are very particular sensitive matters, and they're very limited. So you have to ensure that you're only discussing those and nothing else. There is a very specific way to do the executive session. I do have, under the executive session training module, some detailed checklists for you to use. But essentially, if you go in executive session, you have to announce the statutory authority in detail. You have to allow the news media to attend, but they aren't to discuss the matter or write about it or report about it. You are required to keep minutes, but they can be kept in the form of sound recordings. They don't have to be written out. One of the most important things is that if an employee requests a public session for performance evaluations or discipline, or a board member, because sometimes some board members are under disciplinary matters, the meeting must be held in public, and it's their choice. And so one of the important things is to make sure that you give that employee or board member enough notice that they can decide whether they want to have it in open session or not. And finally, the board cannot reach a final decision in executive session. Executive sessions, as I said, violations are investigated by the Oregon Government Ethics Commission, and they're quite serious about it, and there are civil penalties. So that's just a little bit about executive session. I didn't want to go into too much detail just to perk your interest, and if you want more detail about executive session, we already did the one last Friday, but there is the one on Wednesday at 6 p.m. I'm doing it at 6 p.m. so that in case some directors who have day jobs will be able to attend. So that's just a real glossing of it, but just to give you some basic information, and hopefully you can see the more detailed one. All right, electronic meetings. So meetings can be held electronically too. Telephone calls, conference calls, which you're familiar with, of course, now Zoom calls. One of the things that we'll probably get back to, though it has been waived now, is that if you do any kind of electronic meeting, whether by telephone or by Zoom or a hybrid model, which many of you are doing, you are going to have to provide a space for the public to participate, or not participate, but listen in during the meeting. So that used to be you would have a room maybe with the other board members while some were on the phone with a conference call line there. But to think ahead is that if some of you I know are talking about continuing with like a hybrid model of Zoom, right now you don't have to provide that call-in space or a space for them to listen or a place for them to watch. However, I'm going to assume that when the health emergency is over and that providing the listening device is waived, it's no longer waived, you will have to provide a way for folks to call in or to sit in a room and with a speakerphone you provide, or perhaps even a Zoom session, a laptop set up with a Zoom session for them to look through. So that's one thing we should be paying attention to, is coming out of this when that waiver of providing the room with a listening device has ended, and how that might happen. So you probably want to think about that. One of the other things about electronic meetings is that you need to be careful that you don't hold electronic meetings accidentally. And what I mean by that is by case law, they've shown that you can have meetings, public meetings accidentally or perhaps purposely via phone or email by serial emails and serial phone calls. So if you have a 5-member board and your chair decides to talk and get some opinion from another board member, that's totally fine. But if that chair of yours then calls a third board member or a second board member, so there's 3 of them on a 5-member board, and starts asking the same questions and starts saying, you know, hey, I just talked to Jane and she said this, what do you think? Even though that's not 3 people on the phone, it is clear in case law that you just had a serial board meeting because you've done a relation between 3 different board members through phone calls. So make sure that your board doesn't do that. And it's the same with emails. You've heard me many times talk about use blind carbon copy for emails because you can accidentally have a board meeting by email if the chair sends a message out, or if your district manager sends a message out, or your administrative assistant sends an email out, and your board members start replying to each other like, hey, this is a great idea or not. An example of this that has come up before is a district manager, the copy machine broke and they wanted to get a new copy machine, and so they sent out an email to all the board members asking, is it okay if they buy a new copy machine? Well, you're actually asking the board to make a decision in that point, and they can only make decisions in a public meeting. So there was some banter back and forth between board members. Well, that violated public meeting law. And then the manager waited until they got a majority of board members to say, yes, you should go buy a new copy machine. But by doing that, he asked the board to make a decision, and the board made a decision by email, and that was a public meeting. So you do need to be very careful about not accidentally having an electronic public meeting by email or even by phone call. So that's important for the district manager and for the chair. So as many of you know, I say make sure to use blind carbon copy. Are there any questions about that? Anyone actually have an experience that they want to share or anything before we move on? Nothing at all? Well, this might actually end up being a much faster session than I was expecting. We're about halfway through our slides here.
I have a question.
I hear someone. Does someone actually have something to say?
Mary, yes.
I can't hear. This must be Deb.
Right.
Can you speak up?
Can you hear me now?
Oh, this is Mary. Oh, hi, Mary. Barely.
Hi.
I'll try to repeat what you say.
Oh, I know what it is. I'm Bluetooth to my hearing aids.
I can hear you fine, so I will repeat what you say.
Suppose I go on my Fulbright and I always have to call in by Zoom to meetings. That would mean they'd have to have a special room or a way to call in, or?
Well, we're talking right now, the requirement that you have to provide a space for the public to listen in, and that law was related to conference calls. That is actually been waived at this time.
Right, I got that, but what if it's gone by the time I head out?
What is on? Sorry.
What if they have gone back to the original rule?
Oh, yes. So that is what we need to keep an eye on, because the way I would interpret the law right now, and again, I'm not a lawyer, is that if you're using a Zoom or GoToMeeting as the way to participate, then you would have to provide that. Now, if you're providing the meeting is in person and you're providing another opportunity for besides in person, then probably just having the in-person space is going to be fine. But if that waiver passes or terminates, but people are still doing entirely by Zoom, I think that you are going to have to think about providing that space for the public to be able to look in on the meeting through Zoom. Though usually with Zoom, there's also a call-in number. So probably if you have a conference call line somewhere, but you just might have to provide that space as you would if you were doing a conference call.
Thank you.
Okay. I hope that's clear. Faye has asked, what if I'm emailing the board with additional background information in advance of the board meeting? As long as they do not reply, is this acceptable? Yes. If you're just providing information, that is totally acceptable. I mean, and that happens all the time. You got to think of the district manager, admin assistant will be providing out the packets to the board. They go out by email to everyone, and staff reports, other kind of reports. That's totally fine. What you don't want to get into is a lot of banter or any banter back and forth between board members. There is an exception. It's called the time and place exception. If you're trying to determine when to have a board meeting, and so all you're limiting your emails back and forth to is about trying to find a convenient time, generally that is acceptable. I still don't think that's the best way to do it because it's way too easy to start saying in those time and place emails, hey, don't forget, I think we need to talk about this, or hey, I really want this to be put on the agenda. That would start to get into the territory of a public meeting law, because that's not limited to time and place. So do be careful if you use that time and place exemption for emailing back and forth between directors. Any other questions so far? All right. All right, so one of the things you have to do for a meeting is give proper notice. Most of you are already aware of this, but I'm going to go through it anyway. So there's three kinds of meetings you can hold: regular meetings, special meetings, and emergency meetings. And that's and there's annual meetings and public hearings. We'll just talk about that in a second. For regular meetings, there is no set time, except that you have to give reasonably calculated. What is reasonably calculated? The Attorney General has stated that that's 2 weeks. That's pretty hard for all of us to do, as we know. So at ODA, we say, well, if you can do at least 1 week ahead of time, that would be great. Special meetings are 24 hours notice. And emergency meetings, which they have to be true emergencies, and those are very limited in scope. You have to attempt to notify the media and interested parties, and you have to indicate the named emergency in the minutes. And as I said, emergencies have to be true and they have to be extreme, and there are some statutes around that. There are probably very few, if any, instances where districts would have an emergency meeting. So Sydney asked, how do you decide what warrants a special meeting? Well, a special meeting is anything outside your regular meeting. So if your regular meetings are monthly, if you're meeting any time outside of your monthly meetings, that's going to be considered a special meeting. Often those are things that come up that may require board action. You want to make a hiring decision. Maybe actually you had some kind of like say a fire in your building and you need to get together. That could be an emergency meeting, but probably even that's not an emergency meeting. But you need to deal with a fire or some other incident. You just can't get all your work done in a regular meeting, so you're going to have a special work session. That would be a special meeting. Those are the kind of things that are special meetings. Anything outside your regular meetings. You probably should give as much notice as possible, but 24 hours is what's needed at a minimum. So what goes into a notice? It's very simple: time and place, an agenda. What are the principal subjects? If you know you're going to talk about them, You can always add stuff at the time of the meeting. If you know you're going to be doing an executive session, then you must include the reference to the civic authorization law authorizing executive session. And so one of the things I do see on a lot of meeting minutes is, or notices, is at the bottom it says that the board may call an executive session at any time for the purposes of. That's a little, that's because you're not sure whether you're having an executive session or not. That's probably not required on the bottom. You only need to have executive session on your notice if you know ahead of time you're going to be going into executive session. And you have to cite the very specific reason why you're going in executive session. The other part about a regular meeting notice is that you don't have to pay to get it done. There are instances where you are going to have to pay, most likely, but not for your regular meeting notices. So some examples of posting your regular notice. The most important one is your press release, informing your local media. So you can inform the local media representative directly, or you can send a press release. You're not responsible for that press release being published. All you have to do is make sure that your local paper or whatever your local media representative is informed, and it's up to them whether or not they publish it. Also, you should be sending out to your mailing and interested parties list. If there's still the old-fashioned way of putting it up at the local Grange and feed store, the notice boards, and also to make sure that to know that you putting it on your Facebook page or social media is not adequate on its own. The only way that is still considered adequate at this time, according to the Attorney General, is informing your local media. So getting that press release out to them. The easiest way to do that is to take your agenda. Your agenda is going to have your time and place and what the principal topics on it are, and send that to your local media representative. Your newspaper generally has an email address these days to send information to, or you can send it to a specific reporter. Susan's asking, if you notice an executive session meeting, do you have to say that the public cannot attend or media is allowed? Is there standard language for that aside from citing the ORS? There is in the checklist, there is some standard language. In the notice for the public meeting, all you have to state is that you will be going into executive session for the purposes of blah, blah, under ORS, blah, blah, blah. That's the language, but you can get specifics later. You don't have to put in a notice that the public cannot attend or the media is allowed. You state that at the beginning of the executive session. Also realize that when we go into executive session, the topic in more detail, the board decides who can attend. The public can actually attend executive sessions if that is the wish of the board. I have attended executive sessions. I've seen the board not ask anyone to leave. I've also seen the board ask everyone to leave. So you don't have to say the public cannot attend, because actually they can attend, and that's up to the board of directors. Hopefully I answered your question, Susan. So great. Okay. If you don't notice the meeting properly, or if you actually violate any of the requirements of public meeting law, the decisions are all void. So if it comes up later, someone says, hey, you didn't notice this meeting right, your decisions made in that meeting are actually void, though you can retroactively reinstate them. So then when you have a proper meeting, if you re-vote on stuff, what you voted on is retroactive. This is also true if you ended up not having a quorum at your board meeting. And we've actually seen this where Sandy and I go over the minutes in detail when we can. And we've caught where there actually hasn't been a legal quorum at a board meeting. And we've had to tell the board that all those decisions they made at that board meeting are void. However, they can go back and at the next meeting correct that, repass those motions, and those motions are retroactively reinstated. there any questions on that? All right.
Eric?
Yes.
This is Brandon from Marion Soil and Water. So we have our committees that have been designated by the board, and we don't have them necessarily every single month.
Right.
So that would be considered a special. I mean, it's not regular, but it is, I guess.
Yeah, I mean, it's probably a regular committee meeting, I would say, if they're generally speaking. I mean, you have a schedule. And so I would just notice them as much. I mean, even special meeting, you should give as much advance notice as possible. 24 hours is the minimum, but it's always best to notify the public with as much advance notice as possible. So whether you want to call those committee meetings, which we, excuse me, those committee meetings, regular meetings or special meetings, well, if they're standing committee, they're probably pretty much going to be regular meetings. They just don't meet on a regular basis. I know that's splitting hairs, but hope that makes some sense.
No, it does. That's why I brought it up, because we regularly don't regularly meet. That's exactly what you said. Thank you.
All right. So Al asks, once we get back to in-person meetings and we decide to still provide a Zoom option, does this count as a public listening space? So you only need to provide that public listening space if the entire meeting is electronic. So if you are actually going back to in-person, the place is the in-person meeting that you're providing for people. But they just have the option to participate via Zoom. So hopefully that makes sense, Al. So it's only if you're holding entirely by Zoom would you maybe have to provide that listening space. Okay. Al, did that answer your question? Okay. Oh, I see your thumbs up. Okay, good job. All right. So some notice exceptions to what we just talked about are your annual meeting and public hearings. So if you read the statute, it says in annual meetings you have to give due notice. And due notice is actually defined in statute, which says you have to publish it twice, at least 7 days apart, with one at least 15 days prior to the meeting or hearing. So, and for a long time, we didn't realize at ODA that had to be done for an annual meeting. And hopefully we've notified you all long enough that this is now the case. You have to publish twice, at least 7 days apart. And the cause to be published, because if you read the annual meeting notice, it says give due notice, cause to be published. That means you have to pay for that legal notice, and you got to pay for it twice. Now, cause to be published doesn't, necessarily say you need to do a legal notice. You can do it as an advertisement, and I know at least one district decided to put regular ads in the newspaper because that was less expensive. That's causing to be published, even though it's not a legal notice, and it was cheaper than the legal notice. Also, I suppose if you have a good relationship with your newspaper and you know that they're going to publish it and they do publish it for you, you wouldn't have to pay for that. But the essential way is you got to pay for a legal notice. Doing okay so far, everyone out there? All right. So minutes. The next thing is you have to keep minutes of your meeting. And you have to have written minutes of your meetings. Now, I can't tell if Liesel's up here because I'd love to ask her the question. There is the archives now has a program. If you pay a significant amount of money, that they will actually keep things electronically for you. So there is a little caveat to saying you must have written minutes. But basically, you need to have your minutes in written physical form. And that doesn't mean handwritten, that means, typed out, but on a piece of paper, and you have to keep them indefinitely. And that is because written minutes on paper still keep the longest. And since you have to keep minutes indefinitely, you should keep them on paper, which hopefully lasts as long as indefinitely as possible. So you must write out your minutes, and they must be printed out on the paper. What has to be in your minutes is who was there, what motions or proposals were made, and how each person voted. So when I read your minutes, I need to be able to tell how each person voted. Now, if it's a unanimous vote, and it says the motion was passed unanimously, I can tell by your minutes, and you said who was there, that everyone voted yes. If, on the other hand, and I've seen this, and some of you have gotten phone calls for me, where it says that the motion passed on a 5-2 vote, and that's all that it says, I can't tell how each person voted. So if you're going to not have a unanimous vote, you are going to have to somehow say how each person voted. Usually you say something in terms of the motion passed with a 5-2 vote, the nays being, and you list out the nays, and then you just assume that you extrapolate into saying the other people voted yes. But somehow you have to know how each person voted. Yes, you need to say majority voted and Director S abstained and or voted nay. So that's true. So as long as you just have at least how some folks do it. Minutes don't have to go to an archive. No, you're responsible for keeping your own minutes. However, if you would like, you can pay the Oregon State Archives to archive them for you. They will do that, but you do have to pay for the storage fee. Hopefully I answered your question, Mary. You also need to write the substance of any discussion. They don't have to be detailed. The boards usually will give direction to the staff about how detailed it needs to be. I know when I was at the SWCD and I wrote the minutes, I started and they'd be 5 or 6 pages long. They were incredibly detailed and narrative. By the time I left, they were about 1.5 pages. Both the board and myself decided we didn't want the detail in there. You don't need detail in there. You just need the basic substance. But that really will be up to your board to decide how much detail they want in there. The other thing about minutes is that if you refer to any documents during the meeting, those documents themselves become part of the meeting minutes. So you do need to keep a complete set of minutes. A lot of times you send out minutes to people and they're just the minutes without any supporting documentation. That's okay. But somewhere you need to keep a complete set of minutes, which includes anything referenced. So if in the meeting you reference financial reports, that is part of your complete set of minutes. If you reference staff reports, that is part of your complete set of minutes. And if you have any kind of an annual report that you reference or any other document you might reference, a letter from a constituent or some written comment on something, and you reference it, that is part of the minutes. And so you need to keep at least one full set there. And as far as sending those out to folks, generally you just send out, as I said, the written minutes with all the additional attachments. But if someone asks for a complete set of minutes, please do remember you need to send out the complete set of minutes, which includes all the reference materials. So Brandon asks about a PowerPoint presentation. So, I mean, I guess a PowerPoint presentation is technically electronic, but to be safe, I would probably print it out and put it in with a complete set of minutes for that, because that's part of the official record. The reason I have that subject to public records law there is because there could be some exempt records that would not be part of those minutes, or at least not disclosed. The last part about this is you don't have to transcribe audio recordings of executive sessions. You can just hold on to those. But you are allowed to do written minutes of executive sessions also, because some folks don't record their meetings. So what if you violate public meeting law by not noticing it correctly, by not having a correct number of folks there? Believe it or not, you can be sued by the public. It's a civil suit. I've never seen it done, but you can actually be sued for violating public meeting law. Your decisions are void, as though, as I've said, you can reinstate them retroactively. One of the things, and we talk about this in the executive session and other places, if you have willful misconduct, if you willfully violate public meeting law or any law, you can have a personal liability for that. And as I said before, your complaints go to the Government Ethics Commission. So that actually is everything that I had to talk about. So I'd like to open it up to questions. We have about another 10 minutes here. So if anyone has any questions or anything in general to say, if you something I didn't cover that you would like to know more about, feel free to let me know. I'll end the screen sharing here. So. Does anyone have anything they would like to ask or anything before we end? Because we finished a little early. A lot of silence here. I do thank you for attending. And if hopefully you can make some other ones. Oh, I hear some stuff. Looks we have some more chats here. Nope, just thank yous. Well, thank you for attending. As I said, this is the first time we're doing it this way, so it's all new. I'll stay on for a few minutes. The PowerPoint presentation and this recording are on the website, or the recording will be, but the PowerPoint already is. And then also there is some extra information on there for you too. All right, well, thank you very much. And have a great day, everyone.